Good day to everyone. My name is JERICHA, and I'm your reporter for today. The assigned topic that was given to me was the first part of the revised Corporation Code of the Philippines, also known as Republic Act 11232. It was signed into law by our President Duterte on February 21, 2019. This act amends a 38-year-old corporation code in an effort to improve the ease of doing business in the Philippines. So let's unfold the definitions and classifications of the general provisions of this topic. Let's start with Section 1, which is the title of the code. This code shall be known as the Corporation Code of the Philippines. Let me give you a real quick historical background of the Corporation Code. So, the law governing private corporations in the Philippines is now embodied in Batas Pambansa bilang 68, which took effect on the date of its approval on May 1, 1980. For greater understanding about it, you can see or visit Section 149. So, Act Number 1459 takes place as amended on March 1, 1906 by the Philippine Commission during the American regime. The Act Number 1459 took effect on April 1, 1906. The new code reproduced with amendments many provisions of the old corporation law. In its explanatory note, Cabinet Bill Number 3, which became Batas Pambansa bilang 68, states that the bill is intended to supplant the present corporation law, Act Number 1459, as amended, and to be hereafter known as the Corporation Code of the Philippines. So, the proposed code seeks to establish a new concept of business corporations so that they are not just merely entities established for private gain, but also to be an effective partners of the national government in spreading the benefits of capitalism for the social and economic development of the nation. Let me give you the scope of the Corporation Code of the Philippines, wherein first, it provides for the incorporation, organization, and regularization of private corporation, both stock and non-stock, including educational and religious corporation. Second, it defines their powers and provide for their dissolutions. Third, fixes the duties and liabilities of directors or trustees and other officers thereof. Fourth, declares the right and liabilities of stockholders or members. Fifth, prescribe the condition under which corporation, including foreign corporations, may transact business. 6. It provides penalties for violations of the code. And 7. Repeal all laws and part of laws in conflict and inconsistent with the code. I just want to note that the Corporation Code was enacted under the 1973 Constitutions, which provides a similar restrictions with respect to private corporations. So let's go with Section 2, in which the corporation was defined as a corporation is an artificial being created by operation of law, having the right of succession and the powers, attributes, and properties expressly authorized by law or incident to its existence. So, Section 2 gives a definition of corporation. Its analysis reveals the following characteristic of a corporation. And the first one is corporation as an artificial being. So, a corporation is a legal or juridical person with a personality separate and apart from its stockholders or individual members, who as natural persons and merge in the corporate body. It is not, in fact, and in reality, a person, but the law treats it as though it is a person. The stockholders or members compose the corporation, but they are not the corporation, nor is the debt or credit of the latter that of the former. Because of this separate personality of a corporation, there is a consequence. And here it is. So first, liability for debt, ownership of credit. As a rule, a corporation is not liable for the debts of its stockholders, and the latter are not individually liable for the corporation's debt. Number 2, right to bring actions. So a corporation may incur obligations and bring civil and criminal actions in its own name in the same manner as a natural person. Number 3, right to acquire and possess property. So the property that was acquired by the corporation is the property of the corporation itself, and it may not be sold by the stockholders or members without express authorization of its board of directors or trustees. Their interest in corporate property is only indirect. Number 4, liability for contracts. All contracts entered into the corporation by its regular appointed officers and agents are the contracts of the corporations and not those of the stockholders and members. Again, a corporation cannot be held liable for the personal obligation of a stockholder even if he should be its president. Number 5, tax exemption or liability. A tax exemption granted to a corporation cannot be extended to include the dividends paid by such corporation to its stockholder if such dividends are not exempted from tax. In the same vein, the tax liability of a corporation cannot be enforced against the stockholders nor the personal tax liability of the stockholders against the corporation. And number 6, changes in individual membership. So, as an entity distinct from its member or stockholders, a corporation remains unchanged and unaffected in its identity by changes in its individual membership. It has continuous existence since it would exist even if all the stockholders die. Next would be corporation as a creation or operation of law. Number 1, special authority or grant by the state required. This means that corporation cannot come into existence by mere agreement of the parties as in the case of business partnership. They require special authority or grant from the state. This power is exercised by the state through the legislative department either by a special incorporation law which directly creates the corporation or by means of a general incorporation law under which by operation of said law, persons desiring to be and act as a corporation may incorporate. Second, governing general law or special law. So in the Philippines, the general law which governs the creation of private corporation is Batas Pambansa Bilang 68, otherwise known as the Corporation Code of the Philippines. Private corporations owned or controlled by the government or any subdivisions or instrumentality thereof are created by special law. And number 3, the exception. An exemption to the rule that legislative grant or authority is necessary for the creation of a corporation obtains with respect to corporation by prescription. And the rights of succession of a corporation. So, a corporation has a capacity of continuous existence irrespective of the death, withdrawal, insolvency, or incapacity of the individual members or stockholders, and regardless of the transfer of their interests or shares of stock. But the corporation is by no means immortal. Number one, under the corporation code, the life of the corporation is limited to the period of time stated in the article of incorporation, not exceeding 50 years from the date of incorporation, unless sooner dissolved or unless said period is extended. Second, corporation created by special laws have the right of succession for the term provided in the laws creating them. Next would be the powers, attributes, and properties of a corporation. So, a corporation, being a mere creation of law, may exercise only such power as are granted by the law of its creation. An express grant, however, is not necessary. All powers which may be implied from those expressly provided by law and those which are incidental or essential to the corporation's existence may also be exercised. Let me cite some examples for greater understanding of this part. A corporation incorporated as a railroad corporation has the incidental power to build railroads because such power is necessary for the accomplishment of the purpose for which the corporation is created. Similarly, a corporation expressly authorized to engage in agriculture has implied authority to buy agricultural land because such authority is reasonably appropriate to carry out its express authority. But a corporation engaged or organized for the purpose of supplying electricity to the public has no power to buy and sell agricultural lands because it is not within the power expressly or impliedly authorized by law or incidental to its existence. Next, what is government-owned or controlled corporation? So, government-owned or controlled corporation refers to any agency organized as a stock or non-stock corporation invested with functions relating to public needs, whether governmental or propriety in nature, and owned by the government directly or through its instrumentalities, either wholly or where applicable, as in the case of stock corporation, to the extent of at least 51% of its capital stock. So this means that government-owned or controlled corporations are those directly created by special law, or if organized under the general corporation law, owned and controlled by the government directly through a parent corporation or subsidiary to the extent of at least a majority of its outstanding capital stock. They may be stock or non-stock corporation. So there's two requisites must concur before one may be classified as a stock corporation, namely, first, that it has capital stock divided into shares, and second, that it is authorized to distribute dividends and allotments of surplus and profits to its stockholders. If only one requisite is present, it cannot be properly classified as a stock corporation. As for non-stock corporation, they must have members and must not distribute any part of their income to said members. For further understanding about stock corporation and non-stock corporation, that would be further discussed by our future reporters to the next video. So let's move on and leave it like that. The next one is, What is the piercing the veil of corporate fiction? Let's first define what is corporate veil. So, when we say corporate veil, it is a legal concept that separates the personality of a corporation from the personality of its shareholders and protect them from being personally liable for the company's debt and other obligations. So when we say piercing the veil of corporate fiction, it is a situation in which courts put aside limited liability and hold a corporation's shareholders or directors personally liable for the corporation's actions or debts. It is a fundamental principle of corporation law that a corporation is an entity separate and distinct from its stockholders and from other corporations to which it may be connected, right? But the separate and distinct personality of a corporation is merely a fiction. It is just created by law for convenience and to promote justice. So, when the notion of separate juridical personality is used to defeat public convenience, justify wrongdoing, protect fraud, or defend crime, or is used as a device to defeat the labor laws, this separate personality of the corporation may be disregarded or the veil of corporate fiction will be pierced. So, the condition under which the juridical entity may be disregarded vary according to the peculiar facts and circumstances of each case. No hard and fast rule can be accurately laid down, but certainly there are some probative factors of identity that will justify the application of the doctrine of piercing the corporate veil, and these are: first, stock ownership by one or common ownership of both corporations. Number 2, identity of directors and officers. Number 3, manner of keeping corporate books and records. And number 4, methods of conducting the business. So these are the elements of piercing the veil of corporation fiction. We have 3. So it required that the control must have been used to commit a fraud or a wrongdoing to perpetuate the violation of statutory or other positive legal duty. And of course, the said control and breach of duty must have proximately caused the injury or unjust loss complained of. The next one is powers of corporation. So when we say powers of corporation, it refers to the right or capacity of a corporation to perform all acts or things except only those forbidden by law in its article of the incorporation in the furtherance of their purposes. So we have types of powers of corporation. So a corporation generally has three parties sharing power and control: directors, officers, and shareholders. Directors are the managers of the corporations, and officers control the day-to-day decisions and work more closely with the employee. So we had two types of powers of corporation. First is the express power. When we say express power, these are the powers expressly conferred upon the corporation by law. These powers can be ascertained from the special law creating the corporation or from the general incorporation law under which it is created. The general laws of the land applicable to corporation and its article of incorporations. So for better understanding, the examples for express power of the corporations are to sue and be sued in its corporate name, the power to purchase, to use and sell, the power of corporation to make contracts, the power of corporation to borrow money, and etc. Those are the express power of a corporation. So when we say implied power, these are powers which are reasonably necessary to exercise the express power and to accomplish to carry out the purposes for which the corporation was formed. So I will give one example. Assuming that National Bookstore statement of purpose reads simply to operate a bookstore, then the company may lawfully conduct all activities that are necessary or appropriate to running a bookstore. They can hire employees, they can advertise special sales or leash trucks, and etc. So those are implied power of a corporation. This is where my topic ends. So the further discussion will be done by future reporters. Have a nice day and thank you for listening.